this is what I wanted to just talk about briefly to keep in mind. So I think if you are, like me, a deals person, dispute resolution is just something you push off, and it's just this vague amorphous thing. And I don't care where it happens. Maybe it's going to happen in a public court. Maybe it's going to happen in private arbitration. Whatever. But what we see in these JVs is this really careful tailoring of the dispute resolution process to the underlying issues. And some of this is a review of what we talked about 2 hours ago, but I just want to highlight this. So it's often the case that your escalation process, which goes through those different committee structures, if it's a contractual JV, you see the same thing in equity JVs too, they don't end up in a single tribunal. So what you have here, this is from a GlaxoSmithKline alliance. This is just a depiction of the dispute resolution process there. If you have an IP claim, that will always end up, almost invariably, end up in a federal court. And it's part of it is because of the expertise that exists in certain districts, U.S. Federal district courts in the United States, Northern District, California, District of Delaware, for example, being the leading ones. You want a judge that handles IP disputes day and night to take care of your claim. So that's a piece of it, but really what's driving it is you want injunctive relief. You're worried about that asset boundary problem. You're worried about your technology spilling over to somebody else. Your partner is going to take it and share that with a third party. What you want is a very quick injunction that says you can't take that technology elsewhere. And so that's why you end up in federal court. You can get injunctive relief through arbitration, but it's complicated and it's just a clunky process. So that's why you see those types of claims going to that type of tribunal. For run-of-the-mill contract claims, typically, 62% from this sample will send that to a private arbitrator. So, pick your, AAA, JAMS, whatever it is. Then after the escalation process, it's gonna be arbitrated. What kind of arbitration? Who gets to select a panel? Those types of things. That certainly happens. Sometimes it's a very simple arbitration provision. Other times it goes on for pages. It might be worth thinking about exactly what sort of process makes sense for you. I will say this is one of the more interesting things I had. I've gone around, I've talked to law firms, and I'll present to their IP transactions practice. So these are the lawyers that put together these JVs and alliance contracts. And I'll do a presentation and then we'll just do some Q&A. And one of the questions I ask them is there a specialized group of arbitrators out there that you always turn to in the event of a dispute? And strangely enough, the answer was no. So even in industries like pharma or various tech industries, or like mining, JVs are incredibly important for the extractive industries. Apparently, from what I'm told, there's not a standard set of arbitrators, so it's a little bit more free-flowing. So that's an interesting thing. We often think of private arbitration as a way to get industry-specific expertise brought to play, and certainly they look for people with experience in commercial contract disputes, JV disputes in general, but it didn't seem to get much more refined than that, which is something to bear in mind. The last type of claim is that coordination problem issue. So what if our teams they're just not working well and they have a dispute over the science, right? Like, my molecule, I think the molecule should look like this, and I want to do these treatments, and your scientists want to do something else, or the engineers can't agree on how to code something up. That's where they'll bring, in a very real-time dispute resolution process, they'll bring in an outside expert, just a technical expert, not a lawyer, not an executive, like an engineer, to come in and sort that out on a very quick timetable. So those are your options. And again, they're not exclusive to each other. This is a complementary set. Really what we're talking about is a network of institutions that you can access to resolve disputes in these situations. And it's useful, I think, first of all, just to be aware that exists and you have those tools at hand, and then to think carefully about how they interact with each other. So if you, I would imagine many of your IP disputes are going to be interwoven with contract claims. And it's worth thinking about, well, what do we do with that? What we see in practice happen quite frequently is you bring that IP claim into federal court, And then there's a dispute over what are we going to do with the contract claims. And sometimes the court will move forward with those or sort of wrap them up into the IP analysis. And other times the court will say, no, those are for your arbitration process. I'm just going to do the injunction with respect to the patent infringement claim. And anticipating how that's going to roll and what that means for each other is an important thing to take care of. The temptation is always just to say, well, the litigators will handle this at some point. And it's always a wonderful thing for the litigators to hear, because it means they're going to be creative and make this up, the solution up as they go. But if you can anticipate some of these issues and try to craft the solution ahead of time, it usually pays off in litigation costs down the road. So I thought I'd just ask everybody what the experiences have been with respect to disputes, and have you ended up, you don't have to disclose, the gory details and confidences, but just have you ended up in an arbitration proceeding or in court working through an issue, or has everything been handled sort of, negotiated wind downs, buyouts, that sort of thing?
I ended up in a ICC arbitration, but it was, and it went well. It was significantly easier than I expected. But merging market, we were just concerned about rule of law. So we thought private arbitration was the right way to go. But what you just laid out was brilliant about actually tailoring their dispute resolution to the underlying claim and the outcome that you think would be the theater that you think would be best suited for that claim. I've never seen that before. That's pretty cool.